In the final days of December 1969, a mother carried her 6-week-old daughter through the doors of the Catholic Hospital of APAM. The baby's name was ASAFO, and like any newborn, she was totally dependent on the care of those around her. What should have been a routine hospital stay became a landmark case relating to custody of babies at a hospital. The hospital's rules were seemingly compassionate. Mothers of infants patients would remain on the premises to continue breastfeeding their babies. It was a practical arrangement born out of necessity. Ekua's mother found herself among a small community of waiting women in the hospital kitchen, called upon every 3 hours to nurse their children before returning to wait again. For 5 weeks, this ritual continued without incident. Ekua lay in her cot in the special infant ward while her mother kept vigil nearby. But on the morning of January 14, 1970, that rhythm stopped. Nurse Philomena Ando arrived for her early morning rounds around 5 a.m., moving from cot to cot as she had done countless times before. But when she reached Ekua's bed, she stopped. The baby was gone. The nurse's mind raced back to the previous hours. She remembered clearly. Ekua's mother had fed the child just around 3 a.m. in the morning, the last feeding of the night. The baby had been there, safe in her cot, but now the bed was empty. Rushing to the kitchen, Nurse Ando found Ekua's mother among the other waiting women. When she asked the heavy question of the infant's whereabouts, she answered in the negative. The mother had not taken the child. No, she didn't know where Ekua might be. That moment became every parent's nightmare. The hospital authorities took action. The matron was summoned and the police were invited. Searches and investigation began, but all efforts, baby Ekua ASAFO had simply vanished. Ekua's family were aggrieved and determined to seek justice. In their view, this was a preventable tragedy. They had entrusted their most precious possession to the hospital's care. The institution had assumed responsibility for Ekua's safety and had controlled every aspect of her environment, had dictated when and how her mother would even touch her. If anyone was responsible for her disappearance, surely it was those who held absolute authority over the hospital. They brought an action for negligence in the High Court at Cape Coast. They argued that the hospital had taken custody and control of Ekua. Her mother was merely a visitor, permitted entry only at the hospital's invitation and on their terms. Under these circumstances, the burden shouldn't fall on the family to prove negligence. It should fall on the hospital to prove that they were not negligent. This, again, is the principle of res ipsa loquitur. The thing speaks for itself. And something so obviously goes wrong, and it couldn't occur without negligence. When the defendant has exclusive control over the situation, the law shifts the burden of the explanation to those who were in charge. As the case unfolded in the High Court, something extraordinary happened. The Catholic Hospital of APAM, perhaps confident in their procedures, or even perhaps overwhelmed by the tragedy, chose to call no witnesses. They presented no evidence of their security mechanisms, no testimony about their staff protocols, no documentation of their safeguards. They simply relied on the testimony that Ekua's mother herself had given. It was a gamble that would prove costly. Justice Bredu found himself looking at a case where the baby had disappeared from a controlled environment, where only hospital staff had access, and where the institution charged with her care offered no explanation for how such a thing could happen. The court's reasoning was then very logical. Like a bailment, where someone entrusts property to another for safekeeping, the hospital had assumed a duty of care. True, baby Ekua was not property, but a precious human life. Yet at 6 weeks old, she was entirely dependent, unable to move or think or act independently. Principles applicable to bailments were the same. Those who assume custody must answer for what happens during that custody. With no evidence from the hospital to explain how their security and administrative procedures were adequate, how their care met reasonable standards, or how the disappearance could have occurred despite proper precautions, court reached an inevitable conclusion. The Catholic Hospital of APAM was liable. Baby Ekua's disappearance was the result of their negligence, and their showing in court had put this beyond all reasonable doubt. But then came perhaps the most difficult question of all. What was the value of a lost child? Ekua's family had sought 2,000 new cedis in damages, a substantial sum for the time. Justice Bredu admitted his struggle openly in his judgment. These were uncharted legal territories. There were no precedents to guide him, no previous cases to illuminate the path forward. How does a court put a price on such an immeasurable loss? In the end, he awarded 650 cedis in damages and 105 cedis in legal costs. The numbers seem almost arbitrary, but they represented something more than money. They were an acknowledgement that institutions must be held accountable for the lives entrusted to their care. The case of Ekua ASAFO became a cornerstone in Ghanaian negligence law, establishing precedents that will guide courts when institutions fail to take care of the most vulnerable. Follow Super Law G Studios for more real stories, real cases, real people.